So this is part 2 of mastering contract cancellations. If you remember in part 1, we talked about the 10 reasons a seller may cancel, where the cancellation provisions are located in the RPA, and we also talked about the 6 steps, the 6-step procedure for canceling a transaction. So that's what we're going to go over today, is the 6 steps cancellation. So step 1, if you remember, was time frames. Check the time frame to see if the buyer has performed as required by the contract. So how do you determine the day of acceptance? The very first step in checking the time frame is to figure out when the acceptance of the contract occurred. This has a very particular meaning in the RPA. The acceptance day is the day when the offer or the final counteroffer is accepted in writing and then delivered back and personally received. So for example, the buyer makes an offer on a Monday and the seller signs an acceptance of that offer on Tuesday, but the accepted offer is not delivered back to the buyer's agent until Wednesday. In this case, Wednesday is the day of acceptance, assuming paragraph 31 of the RPA is filled in with the agent's name. For purposes of counting the contract, that day, Wednesday, is day 0. The next day after acceptance, Thursday, is day 1. Next part is, how do you count the days after acceptance? Remember, the day of acceptance is day 0, and the next day after that is day 1. So days means calendar days unless otherwise specified. This means that you count every day, including Saturdays, Sundays, holidays. However, the very last day for performance cannot be a Saturday, Sunday, or holiday. In that case, the last day is the next business day. All the time periods in the RPA are counted in this manner. The only exception is for placing earnest money into escrow, where you count only the business days. So check the buyer's compliance day. After determining the acceptance date and counting the days accordingly, check the provision of the contract that the seller is relying on, demanding the buyer's performance. Another example, the seller is demanding that the buyer remove inspection contingency. The buyer must be given at least 17 days on paragraph 14b3, unless, of course, that was changed either in the original offer or in the counteroffer. Remember, if the last day is a Saturday, Sunday, or holiday, then the seller cannot demand performance before that day. The notice to buyer to perform can be delivered no earlier than 2 days before the expiration of the applicable time frame. Most of the contingencies must be removed within 17 days, again, unless otherwise changed, such as the inspection contingency, the appraisal contingency, and the contingency for return of certain statutory disclosures, such as TDS, NHD, and the lead disclosures. Other deadlines include, and this is default periods in the RPA. Obviously, these can all be changed, but these are the defaults: 21 days for loan contingencies, 7 days for a buyer to deliver verification of down payment and closing costs, 7 days for the buyer to deliver pre-qual letter, 3 business days to put earnest money deposit into escrow, 5 days to remove contingencies after delivery of any report, disclosure, or information for which seller is responsible. The contract specifies that the notice of buyer to perform cannot be delivered any earlier than 2 days before the expiration of the buyer's time. For example, if the seller is demanding that the buyer remove contingencies by day 17, the earliest the notice to buyer to perform can be delivered is day 15. But no delivering the notice prior to 2 days. Step 2, seller obligations. So make sure the seller has fulfilled all seller obligations. So has the seller delivered all disclosures? The seller should be in full compliance with all of the seller obligations at the time the notice of buyer to perform is delivered. What this typically What this typically means in practice is that the seller should have delivered all of the required disclosures and reports within 7 days per the contract. A seller who has not met that basic obligation, but nonetheless demands that the buyer remove all contingencies, is putting the cart before the horse. It's necessary to deliver disclosures before the buyer's obligation to remove inspection and disclosure contingency arises. Thus, the seller's notice of buyer to perform, if sent out before all disclosures have been made, will likely be defective. The buyer may be able to challenge any subsequent cancellation based on that defective notice. So basically what we're talking about here is make sure your seller is in full compliance of the RPA. Everything's been delivered that needs to be delivered before they start demanding notice of forms, cancellations, so on and so forth. Has the seller allowed the buyer the right to conduct investigations? The other critical obligation of the seller is to make the property available for inspection, which must be done during the initial 17-day inspection period of the contract. So if you have a seller who is making it difficult to get in the home and do the inspections, that could, potentially make it harder for them to demand notice to perform if they themselves have made it difficult for the buyer to perform. A seller who cannot make the property available for inspection is in no position to demand that the buyer remove disclosure and inspection contingencies. Does the seller have to complete repairs before giving a notice buyer to perform? This comes up quite a bit. So the myth, a common misconception among buyer's agents is that unless repairs are complete, then the inspection contingency need not be removed. The fact is, seller repairs are not required to be completed until prior to final verification. So under the terms of the RPA, seller repairs are not required to be completed until just prior to the final verification, which would be the walkthrough. So this would typically not be a precondition to the buyer removing contingencies. Therefore, if the buyer does not remove contingencies by day 17, the seller can properly send over a demand to remove contingencies despite the fact the seller has not yet completed repairs. So this is a big one. This one comes up a lot. A lot of buyer's agents will argue the point that the repairs are not done yet. The fact is, it is not. They're not required, if they're going to be doing any repairs, they're not required to have those complete until prior to the walkthrough. So step 3, filling out the forms. Notice buyer to perform or the demand to close escrow must be correctly filled out, indicating what the buyer has failed to do, and the seller must sign it. So can a contingency removal form be used without a notice of buyer to perform? So use form NBP, notice of buyer to perform. One common mistake is when the listing agent merely sends over a contingency removal form and demands that it be signed and returned. The CR form is simply not a demand. The CR form does not qualify as a notice of buyer to perform. The listing agent needs to use a notice of buyer to perform and should not attempt to substitute any other form as a demand. How should a notice be completed? Number 1, check the correct boxes. Notice buyer to perform must specify exactly what action is demanded. Failure to fill it out by not checking the correct boxes will make the demand pointless and defective. Number 2, do not write in a shorter specified time in the notice of buyer to perform. So do not change the 2 days space to something less than 2 days, or write in 1 day or 48 hours. Neither of these times are the equivalent of 2 days and could render the notice of buyer to perform defective. This time period is set in the contract under paragraph 14E. Seller must sign the notice of buyer to perform or demand to close escrow. This is a direct requirement of the contract. Without the seller's signature, the notice of buyer to perform or demand to close out escrow is ineffective. And if you want reference, you can see section 14E of the RPA. So step 4, delivery of the forms. Notice of the buyer to perform or DCE must be delivered to and personally received by the buyer's agent or the buyer, after which the listing agent should obtain some type of verification that it was in fact received. So is delivery to the buyer's agent sufficient, or must a buyer be personally served? Buyer's agent or buyer. So the RPA requires that the notice be personally received to be effective, but depending on how the RPA is filled out, the notice may be personally received by either the buyer's agent or the buyer. So if the broker box on page 9 of the RPA is filled out, then the notice may be delivered to the individual real estate agent for that buyer. If that section is not filled out, then the notice must be personally received by the buyer himself or herself. So that's something, to definitely check on the contracts. Who is able to receive the notices? Did you fill in your name on that section of the RPA on page 9, or did you not fill it in? So here's the example of where it is. So number 31, this is on page 9 of the RPA. How should the notice be delivered? Email, mail, messenger, fax, or otherwise. The RPA allows for delivery by any method. It doesn't matter. However, it's recommended to use the same method of delivery by which every other document was sent. So if you have a transaction in which the buyer has received every document sent over by email without a problem, then it makes good sense to use the same method for delivery of the notice of buyer to perform. So consistency is key on that one. How do you prove personal receipt? So verification of personal receipt. Ideally, of course, the buyer's agent will initial the confirmation of receipt, but this may not happen every time, as we know. The second best solution is to obtain proof from the buyer's agent, him or herself, that the notice of buyer to perform was received. This is sometimes conveniently generated when the buyer's agent email and listing agent emails the listing agent back and angrily wants to know why a notice of buyer to perform was delivered. Any statement in writing, text, messenger, or voicemail in which there is a recognition of the notice received will constitute solid proof of actual receipt. So even if they don't say that they've received it or say confirmed or anything like that, basically if they reply asking a question about it, that could be deemed as actual receipt. A third possibility is conversation notes by the listing agent where the buyer's agent admits in some fashion having received the notice. This is not ideal, but sometimes it's the only way to document personal receipt. To create such a record, the listing agent should note the time and date of the conversation, the general substance of the discussion, and the acknowledgement of the receipt by the other agent. It should be signed and dated. If the notice is met with a complete absence of any response whatsoever, and there has never been any previous issue with communications or delivery, then the listing agent may send out the notice using several different methods and even on multiple days. Having undertaken this extraordinary effort to deliver the notice, any claim of non-receipt by the buyer's agent would surely ring hollow, absent a very good excuse. So if they are, completely ignoring you and they haven't been ignoring you previously, do the land, sea, and air method, deliver it personally, fax, email, text messenger, do it all, do it over a couple days, and that should suffice as being deemed as received. The RPA does allow for a simpler method of proof of delivery, but it must be incorporated into the agreement by checking the other box under 5A and attaching the form DNA, Delivery of Notices Addendum. then merely using the chosen delivery method is sufficient to establish personal receipt. So step 5, counting the days. How do you determine what day cancellation may be issued? The first day of receipt is day 0. And remember, the second day would be day 1. Or actually, the next day would be day 1. Having established that the notice was personally received, then that day of personal receipt is day 0. It doesn't matter what time of day the notice was received. Next day after day 1, whether or not it is a Saturday, Sunday, or holiday, the day after that is day 2. So day 2 lasts all day long until 11:59 at night. It is only after day 2 has passed that the seller has a right to issue a cancellation. The final day cannot be a Saturday, Sunday, or holiday. The final day is usually day 2. No matter how many days the buyer has been given to perform, the final day cannot be a Saturday, Sunday, or holiday. If so, the final day skips to the next business day. So for example, the notice is delivered on a Thursday, but personal receipt is only established on Friday. Friday is therefore counted as day 0. The next day, Saturday, would be day 1, and the day after that, Sunday, is day 2. But with a 2-day notice the buyer to perform, Sunday cannot be the last day. Therefore, the final day skips to the next business day on Monday. The buyer has then all day Monday to perform till 11:59 at night. If the buyer does not, then the seller can cancel on Tuesday. So step 6, the cancellation form. The day after the last day to perform, the seller may then sign and deliver a cancellation form using cancellation of contract form CC. So how does a seller cancel after waiting the proper number of days? Check the applicable boxes on the top and bottom portion of the CC form. The seller is canceling because a buyer refused to remove the contingency, then the seller will check box 1B at the top portion of the form. The buyer has not taken a contractual action, then it is 1C. The buyer has not closed escrow after being given a demand to close escrow, then the seller will check other and write in buyer has failed to close escrow after being given a demand to close. That's all you need to write in. Keep it short and sweet. May a seller cancel if a buyer removes contingencies first? Absolutely not. A buyer may remove contingencies prior to the seller's cancellation. If prior to the seller canceling, the listing agent receives a contingency removal from the buyer as demanded, then in that case, the seller no longer has any right to cancel. Even if the seller were to attempt a cancel, the parties would remain in a binding contract. Cancellation is a unilateral act regardless of whether there is an open escrow. The 10 reasons for cancellation, as outlined previously, confer upon the seller a right to cancel unilaterally. It is irrelevant whether the buyer agrees to the cancellation. As long as the seller has properly followed the correct procedure, the seller's cancellation will be effective. So may a seller cancel if buyer removes contingencies first? No, a buyer may remove contingencies prior to the seller's cancellation. The listing agent receives a contingency removal from the buyer as demanded. Prior to the seller canceling, the seller will no longer have a right to cancel. Even if the seller were to attempt to cancel, the parties remained in a binding contract. So, is cancellation effective if buyer will not sign cancellation of escrow? The answer is that the RPA provides the seller with a unilateral right to cancel the contract, and the seller may therefore cancel the contract without the buyer's consent. Escrow, however, may require signature from both parties to cancel the escrow, but the fact of an escrow being open does not affect the validity of the seller's cancellation. The buyer's refusal to sign the bottom portion of the CC form does not preserve the buyer's right to buy or render the seller's cancellation ineffective. So it is therefore canceled. If you'd like to look up more information about this, you can always go to the risk management section of car.org. There's lots of good information in there. Always give me a call, text, email if you have questions about things. Hope you learned a little bit more about cancellations, and we'll be following this up with part 3 of mastering contract cancellations.